Our guest is Steve Singer, who's a professor at the Loyola University College of Law. Steve Singer graduated from Harvard Law School, went to the Public Defender Service in the District of Columbia, where he was a public defender for a number of years, and then went to Louisiana, where he joined the Louisiana Capital Assistance Project, and for 4 or 5 years, was doing capital cases in Louisiana. He went to the law school, but then when Katrina hit in 2005, took a leave of absence and went to build a new public defender office in New Orleans. And I want to talk with Steve today about both the building of that public defender office and capital representation in Louisiana. Steve, thanks for joining us.
My pleasure.
Would you just describe to us what was the representation for poor people accused of crimes like in New Orleans, Orleans Parish, the city of New Orleans, before Hurricane Katrina hit the city in 2005?
Well, what you had was, and I'm originally from Chicago, and what you had is what I would describe as a very classic patronage system. The judges ran the public defender's office. They didn't do it directly. They were the local criminal court judges appointed a board of like 3 to 5 to 7 members who then ran the indigent defender office. But the board members were selected by the judges, and they were basically private criminal defense lawyers who were friends with the judges and contributed to their campaigns, their judicial campaigns, and got other people to contribute to their judicial campaigns. And so then they were on the board, and they were then able to hire their friends and the judges' friends as public defenders. And the indigent defense system, if you were to devise a system that was set basically to screw the clients, that's what you had. What you had was you had public defenders who were part-time and on salary. So they were part-time in the sense that they had private criminal defense practices, and then they had a part-time salaried position as a public defender. And what you'd have is you'd have like two to four public defenders assigned per judge, per courtroom. And they would split it up the way they negotiated with their judge. So you might have one lawyer take Mondays and Wednesdays, the other lawyer take Tuesdays and Thursdays, and then maybe they'd alternate Fridays. Or they'd do a system where they'd be on 1 week as a public defender, and then they'd be off for 2 weeks, and the next public defender would take the next week and then the next week. And what that meant for the clients was, since they were on salary, it didn't matter whether they spent 2 hours or 2 minutes on a case. They got paid the same. So obviously the financial incentive was to spend as little time as possible on your indigent public defender cases so that you could spend more time on your private paying cases. And so this obviously worked to the great detriment of the clients because they got as little time as possible. And one of the things you have to say about the lawyers is some of these lawyers they weren't necessarily bad people, but they were stuck in a really bad system because at the time, for example, New Orleans, the public school system was terrible. So if you give a person a choice, well, you can spend the right amount, you can spend more time on this public defender indigent case, or you can spend less time of it and you can earn some more money and send your kids to private school, to a good, decent school and get your kids a decent education. Well, that's no kind of choice at all, obviously, for people. So it wasn't necessarily that the individual lawyers were bad people, but they were stuck in a system that really was set up to make sure that as little time as possible was spent on indigent defense clients.
And what kind of support did they have in terms of office space, investigators, and other things that are deemed pretty essential to representing people accused of crimes?
They had nothing because, remember, it's a patronage system. And so in a patronage system, any money, every penny that goes somewhere other than to a person is wasted money. Because when you spend money on people, they then can contribute back to your campaigns, and they can get their friends and family and other people to contribute to your campaigns. But computers, office space, Xerox machines, experts, investigators, all of these other things other than lawyers they don't contribute to judicial campaigns. They don't send the money back, a percentage of the money back. They don't kick it back. So as a consequence, they had nothing. The judges gave them for free one room in the courthouse because, of course, the judges didn't want any money going to office space either. But it was like one room. There were no private offices, no place to meet privately with clients or family members or witnesses. They had 4 computers, 2 of which were hooked up to the internet by dial-up connections. They had 1 Xerox machine that only worked some of the time. They never had to file any motions because the judges weren't require them to file motions because, again, that would be wasted money that wasn't going to people's lawyers' salaries that could then come back to the judges. So they had, I went through the books, and the year before Katrina, for approximately 12,000 cases, all told, they spent, in that entire year on 12,000 cases, they spent $9,000 on experts.
Wow. That's
right, which
amazing.
is, from doing capital work,
Right.
spend $9,000 in an hour and a half,
Right.
In a morning.
Now, were these lawyers also doing capital cases?
The office had a capital unit as well. Those lawyers were generally full-time, but when I took over the office, the capital lawyers, the national ABA standards are like 1 to 2 capital cases per lawyer per year, and the Louisiana state standards were a little bit more generous. They were like 2 to 4 capital cases per lawyer per year. These lawyers had, on average, around 15 to 18 capital cases. Some were over 20 capital cases for an individual lawyer at a time.
Let me ask you this. What was the situation after Katrina hit in terms of people who had cases pending in the courts?
Okay, what happened after Katrina was the Public Defender's Office was funded largely based on fines and fees on everyone who was found guilty of any criminal offense, which in Louisiana included traffic offenses. So by and large, traffic offenses funded the Public Defender's Office. Obviously, once Katrina hit, there were no street lights, there were no stop signs, there were no cars, there were no people, there were no police and law enforcement doing traffic enforcement, at least. And so the funding completely dried up, which meant the Public Defender's Office basically went down to, I think, 1 head, 5 lawyers, and 1 administrative person. And what happened to the clients was, one of the things that the pre-Katrina office did not have was they didn't have any sort of case management system. So they didn't know who their clients were. They would just walk into the courtroom, and whoever showed up in the courtroom that day, they represented. So when Katrina scattered everybody, they had no list of people. So all of the defendants got transferred to jails throughout Louisiana and some even to other states throughout the South, and they were just lost in the system. They were nameless, faceless, and they basically suffered miserably.
Because, if I understand it, the jail there in New Orleans, what's called the Orleans Parish Prison, flooded, right? So the inmates who were in there had to be taken and distributed all across Louisiana, and as you said, even some out of state.
Right, and it was truly horrible. It completely flooded, and you can look back at the pictures post-Katrina. There's the Broad Street overpass that goes over the expressway right by the jail, and basically you had the inmates swam, waded and got through all of the muck to this bridge overpass where it was dry, and they generally spent from 3 to 7 days in basically hot blazing sun, 95 to 100 degree temperatures, with no food and no water, surrounded by a bunch of guards who had some food and some water but would not share it with the inmates. Then they got transferred to what was called Hunt Correctional Center, which was the classification prison where most inmates would go before getting sent to various prisons. And all of the Orleans Parish inmates were put in one big outside pen that was fenced in a field, which meant also you had juveniles, you had young kids, you had people charged with disorderly conduct or drunken or carrying an open container and very minor offenses, all mixed in with people charged with murder, rape, armed robbery, very violent people. And you had strong men with young boys, young kids, and they were all mixed in one big pen. And it was so dangerous the guards wouldn't even go in. what they would do at feeding time was the guards would just stand outside the fence and they would toss over the fence sandwiches and bottles of water. And of course, what happened in that environment is if you were big and strong, you got food and water. If you were weak or meek or mild-mannered, you didn't get anything, and you got beat up, and you suffered. We're talking unspeakable abuse. And also, eventually, some of these inmates then got dispersed to jails throughout rural Louisiana. Most of, obviously, the Orleans Parish inmates, you're talking are African-American men, and they got sent to rural Louisiana where they were it's largely white, and they suffered horrible abuse at the hands of prison guards at these local jail facilities. And then also the prison guards would let other prisoners, other inmates, abuse them, beat them. I mean, literally like just horrible, being beaten up, raped, just horrible abuse.
And there were no records regarding these people, so you didn't know whether somebody perhaps should have been released the next day, but they could be lost out in one of these jails somewhere, right?
Right. There were no records. The Public Defender's Office didn't have records, and so they were really nameless and faceless. And one of the, of course, things that was really typical of the Louisiana justice system was, if during Katrina, if you were charged with a really serious offense like murder or rape, and as a consequence of Katrina and the flood, the evidence was lost. Well, if after a year or two, if you spent a year or two with no lawyer and just sort of moving throughout the system, and then eventually at the end you got released because there was no evidence, well, you kind of made out like a bandit. On the other hand, if you were charged with a very minor offense like disorderly conduct or an open container, and were in for like a day or 2 or 5 days right before Katrina hit, and you spent 6 or 8 months in this system getting abused and raped and beaten up, you, of course, really got the short end of the stick. And so, of course, the people who were charged with very minor offenses, who we would all agree were least deserving of any bad treatment, they got the worst of it. And then, of course, the most violent, dangerous people, they sort of made out like bandits.
Tell us what you did to try to what you did, in fact, do to restructure the Public Defender Office in New Orleans.
Well, what we did was there was a small group of people who sort of immediately after the storm sort of recognized this as an opportunity. There were some people in the Capitol field, a guy by the name of Ben Cohn, who does capital litigation, and then the chief judge of the court at the time, who was Calvin Johnson, who had been a public defender and been a good advocate, even on the bench, for indigent defense, and had decided the PERT decision on ineffective assistance of counsel due to caseloads back in the early 90s. We recognized this as an opportunity. And the biggest opportunity was because all of the funding dried up. The Public Defender's Office had to lay off all or almost all of the lawyers, which meant because it had been a patronage system, once the money dried up, the judges no longer had an interest in it. And once all the lawyers were laid off, you didn't have a vested group interested in keeping the old system and their jobs and keeping things the way they were. And so we took this opportunity. And basically, because the funding dried up, we got some help from, I had a friend, a Harvard Law School classmate who was in charge of funding at the Soros Foundation, and we put them together with the chief judge, Calvin Johnson, and were able to leverage some emergency funding into reforming the office. And initially, really, Calvin Johnson did a lot of the heavy lifting in terms of getting the judges to, the old board, everybody had sort of moved and left New Orleans, and so we got the judges to appoint a new board that was really interested in reform. It had Derwin Bunton, who I think you've spoken to, and Denny LaBeouf on it. It had somebody from Tulane and from Loyola, Pam Metzger and Dane Cialino, and some local lawyers who were interested in reform. And then, and I got hired on basically as the person on the ground to reshape the Public Defender's Office, because as Calvin Johnson put it, he came to me and the dean, and he asked the dean to loan me out from Loyola Law School to fix it, because he was like, Well, Steve's the only one who's actually been a public defender in a good functioning public defender's office and who knows what one of these things looks like. And it's because I had been at the Public Defender Service in Washington, D.C.
And what were the fundamental changes that resulted?
The biggest change, and I would say the absolute most important thing, and sort of, I guess, what I would call sort of the dirty little secret about public defense and indigent defense, is the most important thing is not the structural things or sort of the way things look structurally or the system, but the most important thing is the people. You have to have dedicated people. As you yourself know from doing capital defense in the South, you can have low salaries and small resources, but if you have really dedicated, committed, energetic, smart people, lawyers, you can go a long way. Of course, good lawyers and good dedicated people will do better in a good system and a good structure than in a bad structure. But if you have bad people who aren't interested, it doesn't matter how good a system or structure you have. It doesn't matter what the funding looks like. It won't be good. So the first thing I quite frankly did was I just started hiring people. I just started hiring good, young, energetic people to fill up all the spots. And as I got more money, I made sure I immediately hired people to fill up that money so that the judges and the other political powers couldn't force some of the old people back into the system. So
and you hired people full-time, right?
That was one of the first changes we made. Was we immediately eliminated the part-time system. Everyone was full-time. They had to be a full-time public defender. We raised their salaries to match the district attorney's office salaries so that they could have a good living wage, and we created a real salary structure instead of this just flat part-time $35,000 fee. So you got more money as you got experience. We hired investigators. One of the first things I did was the investigators that they had were basically former cops just double dipping in the system. And so we've got rid of all of the investigators and hired new investigators. I hired some investigators from the public defender's office in DC to then create like an intern investigative program. We hired social workers. We got office space. You know, one of the first challenges to do was we got office space, computers, laptop computers that they could take into court and plug in. They didn't have any of these basics. There was no voicemail system. They had no phone system. So we had to get a phone system with voicemail. We got office space with offices for meeting with clients and with witnesses and with family members. Right, the way they used to take messages was there was just one phone line, and they would call in, and people would just pin a message. A secretary would just pin a message to a message board. So we got a real voicemail system. Just things that the normal accoutrements of a regular law office.
And then the way you approached representing clients, you said before they didn't even have files, but now
Right.
You took a different approach, as I understand it.
We created a case management system. The other thing that was very symptomatic of the system was in Louisiana, you would get arrested, and then your bond would be determined at a first appearance. But then the district attorney's office had anywhere from 45 to 60 days if you were in jail, up to 150 days if you bonded out to file charges. And the public defender's office didn't represent anybody during this pre-charging time. So it could be anywhere from 2 to 3 months if you were in jail, up to 6 months if you were out of jail, before you ever got a public defender or a lawyer assigned to your case. And of course, after 6 months, if you had an alibi or if there was evidence, it was gone. It was long gone by that time if there was evidence to prove your innocence. So one of the first things we started doing, we went full-time lawyers and to a system of vertical representation. Where
what do you mean by that?
Assigned lawyers right away at first appearance.
And then and by vertical, you mean those lawyers stay with the client all the way?
And that lawyer, they would get assigned a lawyer at first appearance, and that lawyer would stay with them throughout the case, through all the stages of the case, all the way through trial and sentencing. Rather than the old system where whatever lawyer was in the courtroom at the time, on the day you walked in, that's what lawyer handled your case that day, whether it was the same lawyer or a different lawyer than you had before.
And how did this was a huge change then for New Orleans? I mean, before the lawyers had almost acted like clerks. They were in the courtroom and they handled, as you said, whatever came in. If lawyers were following clients, they're now going to different courtrooms. So it's not quite as smooth an operation as it had been, right?
Right. Of course, this old patronage, because the pre-Katrina system had been set up by the judges, it worked extraordinarily well for the judges because the lawyers just came to the courtroom. And as you said, they were just like the clerk or the court reporter or the deputy. They were just part of the accoutrement of the judge of the courtroom. And they would just facilitate, they were to have a lawyer, a name for the Sixth Amendment purposes on the transcript and on the docket, so that the judge could move the docket. Once we went to the system of vertical representation, of course, the lawyers were running around from courtroom to courtroom and were also going to the jail to see their clients, which was a tremendous novelty for the judges. And they, of course, did not like the system because it meant things took longer. They could not get on and off the bench as quickly. They used to generally leave the bench by certainly well before noon most days, unless they had a trial. And so their reaction to that was to try and use the contempt power to lock lawyers up in order to try and force things back the way they wanted them. One of the first things I did when I started hiring lawyers is I made a commitment to all the lawyers that if they ever got in trouble with any of the judges, I wanted to keep all the heat on management and off of the individual lawyers, because the individual lawyers were the ones standing next to the clients and had to represent the clients. I and the other administrators, we had no clients. So I wanted all of the judges in political anger focused on management and off of the individual lawyers. And I wanted just the individual lawyers to say, look, here's Steve Singer's number, or here's Christine Lehman's number. They're the ones in charge, call them. And so as a consequence, I would go to court, and whenever anyone had to go to jail, I made sure I was the one who went to jail, not the individual lawyers. So one, we could keep the individual lawyers working on the cases, and also so that the judges wouldn't take it out on them and the clients.
And you were held in contempt and taken into custody a number of times, were you not?
Oh, yes, many times. I was probably cited for contempt maybe somewhere between 10 and 20 times, held in contempt probably 8 to 10 times, and locked up and put in jail probably 8 to 10 or 12 times, especially during the first year or two that I was there. But we were ready for that, and because of my background in capital litigation, we had people set up with the right pleadings to file and the right documents to file. That it was never for very long. And one of the things I had learned from basically from you and from Clive doing capital work was the beauty of sort of contempt was we could pick and choose when to fight and when not to fight. We could pick and choose our battles. So, and the judges were terrible lawyers. They weren't very good at litigators because they never had to really litigate because they were judges. They got to rule, which meant out of all the times I was held in contempt and thrown, not one ever stuck. I never lost one of these. In all the times I was cited for contempt and held in contempt, 20 times over a couple of years, I never lost a single one of them. Because if you pick and choose carefully where you fight your battles, you pick and choose on ground that you can win.
And you would take these to the appellate courts and they would vacate the contempts, right?
Right, and they would vacate the contempt. The procedures were, one of the things was I just learned a lot about the minutiae of contempt procedures, and they were complicated enough that the judges could rarely follow them precisely and correctly in order to do it right. And you'd win. I mean, like a good example of that, for example, was in one case, a lawyer was too ill to do a trial. So the judge made me do the trial, and I, of course, knew nothing about the case. And so I told the judge I wasn't going to do anything because I didn't know anything about the case. I couldn't do anything intelligently. And so the judge started voir dire and had the prosecutor do her voir dire. And then told me, okay, it was my turn to do my voir dire. And I told the judge back in chambers, I said, I'm not going to do anything. I'm just going to stand up and say, I'm sorry, ladies and gentlemen, I can't ask you any questions because I don't know anything about the case. And the judge, said, well, we're going to go out there and you're going to go do voir dire. And she ordered me out there. And of course, did exactly what I said. And she stopped the trial and excused the jury and then held me in contempt. But of course, she was holding me in contempt for not asking any questions in voir dire. Well, obviously, that was not going to stand up because if a lawyer doesn't want to ask any questions in voir dire, there's nothing that says that that a lawyer has to ask questions. So they would fight on sort of foolish grounds like that, where I could always win.
Well, let me ask you this. How would you say, since 2005, with this new office, with a new approach to handling cases, where is indigent defense, the representation of poor people accused of crimes in New Orleans today?
I think it's certainly vastly improved from where it was right before Katrina and certainly after Katrina, but it's much better than it was before Katrina. Just to give you an idea, the total funding for the office pre-Katrina was about $1.75 to maybe $2 million. Maybe some years it was $2.1 million per year. By the time I left in 2009, it was $6.2 million, and subsequently it went up from that. And a lot of people have heard in the news about recent cuts to the public defender's budget, but those recent cuts were cuts back from $9 million back to about $6.5 or $7 million. So you're still talking a good 3 or 4 times what it was in terms of resources, what it was pre-Katrina. And then, of course, the resources are being used much better. You have full-time, all lawyers are full-time. You have no part-time. You have a good supervisory structure with experienced lawyers in supervisory positions and good, young, energetic lawyers being hired. The hiring isn't just local from the local private criminal defense bar who contributes to judges' campaigns. Instead, they hire nationally from the top law schools all around the country, just like a good law office would. And they have several social workers on staff. They have a whole pre-charge unit that deals with clients sort of in this pre-charge phase with their bond and getting work and getting situated back into the community. So it's significantly better. Now, some of the progress has slowed down as sort of state budgets with the recession and the end of the federal stimulus. Some of the fast advancement that we had in the first 3 or 4 years, things have sort of leveled off. But I think they're still well positioned and well situated to take advantage once the economy revives and state budgets revive, to take advantage and keep progressing forward. And one of the things I try and tell people is I came from the Public Defender Service in Washington, D.C., which is regarded as a great public defender's office. But even the Public Defender Service in D.C. wasn't in 1975 what it is now. It takes 20, 30, 40 years to really build a really good, solid office like that. And so I think you have to take the long view. And so there'll be some ups and downs, and they're probably in a little bit of a leveling off or a down period now. But I expect that they'll be well positioned to take advantage and keep moving forward, I think, over the long haul. I hope so.
Let me ask you this, Professor Singer. Could we switch topics just a bit, and let me ask you to talk about a person facing the death penalty in Louisiana. Louisiana still sentences a number of people to death. It has a number of people on its death row. What is the quality of representation in Louisiana for people facing the death penalty?
It is very uneven. It's very uneven. The state operates a number of the State Public Defender Board operates a number of capital programs that are basically regional capital programs. There's one up in Shreveport in Caddo Parish for sort of the northwest part of the state. There's one in Baton Rouge for the central part of the state. There's one down in New Orleans for the sort of southeast region of the state. And then there's my old office, Clive's old office, LCAC, the Louisiana Capital Assistance Center, that's sort of a super regional office that goes around. and it sort of depends who you get. There are some very good, high quality lawyers. Certainly the people at LCAC, Richard Burke, Christine Lehman, Elizabeth Coe, the lawyers at that office are really quite good. And if you're lucky enough to get them on your case, or them working with other local lawyers on your case, you can get quite good representation, which of course, as you know, generally results in no death penalty if you have decent lawyering. And there are a number of lawyers. Kerry Kucha in the Southeast, the New Orleans office. He's a very good capital lawyer, and he runs a very good shop. But elsewhere in the state, if you're not fortunate to get one of these really good lawyers, if you get just a local lawyer or one of the weaker capital programs in the state, then you're in really dire straits. Then you're in trouble.
And occasionally, does this still happen? I know in Jason Reeves' case, it was first handled by one of these regional offices that you mentioned and was a hung jury at the guilt phase. But then the local public defender who protested that he had so many cases, but against his will, was forced onto the case. And of course, that pretty much decided the case right there. Reeves was sentenced to death. Does that still happen?
That still does happen, and it especially happens where Jason Reeves happened in Lake Charles, up in Caddo Parish in Shreveport, sort of in the northern and western parts of the state. They try and keep out the best lawyers, who are not surprisingly, are in the big metropolitan regions of Baton Rouge and New Orleans, which are generally the most desirable places to live and where there's a lot of good legal talent. And so that sort of thing still does happen, and there's a lot of resistance, I would say especially now in Caddo Parish, up in Shreveport, up in the northwest corner of the state, to anyone from down in the New Orleans, Baton Rouge area coming up there. And that generally determines your fate. Yeah, Jason Reeves was a really stark example. They saw what happened with good lawyering, so they decided to change that. And of course, that changed the outcome.
And unfortunately, you're saying that still happens in some places, and particularly in Shreveport.
Yeah, I would say particularly in Shreveport, in the the further north and west you get, the closer you get to the Texas border, to Houston and Dallas, out sort of the western part of the state. That's still a real problem, where they are extremely resistant to people like the Richard Burks and Christine Lehmans and the really good capital lawyers. For example, previously, one of the big death penalty jurisdictions in the state, one of the four big ones were Jefferson Parish, Louisiana, which was the white flight area from New Orleans, Baton Rouge, East Baton Rouge, Caddo Parish up in Shreveport, and Calcasieu Parish, which was Lake Charles. Jefferson was one of the worst. LCAC, Richard Burke and Clive Stafford Smith and Ben Cohn, they basically made Jefferson Parish a project. Jefferson Parish now they're not interested in bringing capital cases anymore. They just don't even charge the death penalty anymore. The local prosecutor, not officially but unofficially, has basically said it's not worth it. We'll just take the life without parole. And they've shut down the death penalty in one of the four biggest jurisdictions. So it shows you what good lawyering can do. But then obviously the opposite is true elsewhere in the state.
And we've seen that in some other places that are talked about in the materials that people have for the course, which is other places like Philadelphia and places that have started capital defender offices, and the difference that is made with regard to representation.
It's unbelievable. I mean, one of the things I'd like to say is that other than one volunteer, since I've been in Louisiana since 1999, there was one volunteer a couple years ago. And then there was Les Martin in 2002. And you're talking, so in the past 14, 15 years, there have been 2 executions in a deep south, southern, high death penalty state. There have been 2 executions. And the reason for that is basically during the mid to late 1990s and early 2000s, you had you're talking about basically 5 lawyers. You're talking Clive Stafford Smith, Denny LaBeouf, Nick Trenicosta, Neil Walker, and Ben Cohn. 5 very committed lawyers for working hard shut down the death penalty in the state of Louisiana, essentially.
Well,
Just a small, it's amazing what a small group of really smart, talented, committed lawyers can do, even in a death penalty hotbed location like Louisiana.
And this is both at the trial level, but also in the appeals process that those
right,
lawyers.
You had 3 or 4. You had people like Denny LaBeouf and Clive Stafford Smith and Neil Walker and myself doing trial work, and then you had people like Nick Trentacosta and Ben Cohn and Denny LaBeouf doing appeals and post conviction, and handling it all the way through, and that basically shut it down. And now that a lot of those people have left, we're worried what things are going to look like 5 or 10 years down the road, that they won't look like the last 10 or 15 years. But it is remarkable. I mean, nothing makes your article on how the death penalty is not for the worst crimes, but for the worst lawyers true than if you look at Louisiana from the early 1990s to the present.
Professor Singer, thank you very much for your time and for your insights. We are most grateful.
My pleasure.